It's noon and we are recording. So I'm going to go ahead and get started, and people can still join in, and we'll get going. So good afternoon, everyone. Hope everyone enjoyed the long weekend and had some time to remember what the holiday is all about. Thank you for coming in on a Tuesday after a long weekend and joining us for today's webinar, the new cannabis law considerations for towns and villages. My name is Katie Malinowski, and I am the Executive Director of the Tug Hill Commission. For those of you who may not know, the Tug Hill region covers 2,100 square miles in portions of Jefferson, Lewis, Oneida, and Oswego counties. The Commission is a small, non-regulatory New York State agency that provides technical assistance in the program areas of land use planning, local governance, community and economic development, and natural resources management. A few housekeeping items for this webinar: everyone is muted and your video is turned off. We have a chat box on the bottom, so please enter your questions in the chat box throughout the presentation, and our presenters will try to answer them as they go. If not, we will catch up at the end with any additional questions. And with that, I'm going to do brief introductions. Today's presenters are Wade Beltramo, General Counsel for the New York Conference of Mayors, and Sarah Brancatella, Counsel and Legislative Director for the Association of Towns of New York State. And they are, they've done a few presentations already about the new law, and they were kind enough to agree to do another presentation jointly. So towns and villages could hear from them. We've been having a lot of questions at the Tug Hill Commission and wanted to make sure the word was reaching our region. Plus, I think we have people joining us from across the state today. So Wade, as I mentioned, is General Counsel to the New York State Conference of Mayors and Municipal Officials, which is a voluntary membership association which represents New York's city and village governments. As General Counsel, Wade represents NYCOM and oversees NYCOM's legal staff and amicus, and I'm not going to say this right, curiae program. In addition, he advocates on behalf of NYCOM's members at the state and federal levels, speaks regularly on issues affecting New York's local governments, and aids its members as part of NYCOM's Municipal Inquiry Service. Wade joined NYCOM in April of 2002 after serving as Assistant Corporation Counsel in the New York City Law Department. Prior to that, he was an analyst in the New York City Mayor's Office of Operations. And Wade has a big conference next week. And so I'm very thankful that he was able to take some time out to do this presentation for us today. Sarah Brancatella is Counsel and Legislative Director with the Association of Towns. There she coordinates Association of Towns legislative advocacy, regularly presents on new legislation and other areas of interest to towns, manages AOT's legal program, and works on members' inquiries. Sarah is a graduate of SUNY Geneseo and the University at Buffalo School of Law. So with that, I will turn it over to Wade and Sarah. Thank you.
Thanks, Katie. We're going to get started. We're going to dive right in. As Katie mentioned, Sarah and I are going to switch off as we go along today. And while one of us is speaking, the other is going to try to manage and triage the chat box to answer any questions that you have. And we'll be happy to stick around and answer whatever questions people have at the end as well. So there's a lot of material to cover. As Katie mentioned, both Sarah and I have done this presentation for our own members a couple of months ago, back in April. And one of the things that I discussed as the theme for that webinar was it's TBD, to be determined, because while we have, I think, a lot of information for you that's going to be relevant and will answer most of your questions today, there is still a lot to be determined. The state agencies are just standing up right now. They have to get up and running and staff the agencies. They have to promulgate rules that are going to be extremely important to what happens, how the cannabis law is implemented, how it impacts communities, how licensees are operating and get their licenses. And so we still have a ways to go and a lot of information still to be gained from those agencies. So, but with that in mind, let's delve in with what we do know today. one of the things I'll note is this didn't come out of nowhere. The law, which is known as the Marijuana Regulation and Taxation Act, also commonly referred to as the MRTA, it was enacted by the state legislature this year. The original proposal for this goes back to 2013. So again, this had been through many iterations and different versions of the statute over the years. The governor first proposed this in the 2019-2020 executive budget, and then they enacted it as a standalone legislation this year. Many of the provisions go into effect immediately. Some of them are going to be phased in, and Sarah and I will try to highlight that as we go forward here today. What's effective right now and what's effective, next year or 2 or 3 years from now. I think it's important to understand the purpose of why the legislature did this. I mean, the first thing to note is New York is not blazing any trails here. We are not the first state to legalize what is commonly referred to as adult use cannabis. The Colorado, California, Oregon, Washington, our neighbor, Massachusetts, which it's been legal there for 2.5 years now, since November of 2018, right? 2018, when they first started selling marijuana. You didn't need a prescription. It was for recreational use. And so we're kind of just getting caught up in that instance. So the purpose of this was to kind of catch up, to create a regulated and taxed cannabis industry, because New York has been losing a lot of revenue, both to illegal and legal sales. People going to other states, buying cannabis, buying marijuana, bringing it back and consuming it here in New York. And also, we didn't really have a regulated market. Cannabis has been largely decriminalized now for many years in the state of New York, and there's a difference between decriminalization and legalization. I'm not going to bore you with that today, but decriminalization didn't create a regulated market, and by that I mean a market where you could grow, process, distribute, have retail establishments. We didn't have that. We still don't have that in New York, not yet. The other main purpose was to provide for social and economic justice related to the sale and use of cannabis. I mean, a lot of people look at the war on drugs that we've had now for many years nationally, and even in New York State. New York State goes back to the Rockefeller drug laws more than 50 years ago that really negatively impacted many communities of color in particular, and that impact has been disparate. There's quite a few studies that show the consumption or use, particularly of marijuana, kind of is the same regardless of race, and yet the war on drugs and the war on marijuana disproportionately impacted communities of color. And so that's another stated purpose of this. And you'll see how this kind of plays out as we go through a discussion of the MRTA today. A couple of things to note. I talked about things that are take effect immediately. And right now, as we all sit here, the possession and use of cannabis in New York State is legal. It is legal in the state of New York. Even though we can't sell it because there's that aspect of the regulated market doesn't exist yet, individuals could go to Massachusetts or some other state. They could purchase and bring back here, and they can possess and use to a certain extent. Possession has its limits, how much you can actually possess, and we'll talk a little bit about that later. The actual sale of adult use cannabis is not expected to begin until late 2022 at the earliest, and maybe a little bit later. I will note that the state is going very fast. They are working very, very hard at getting the agencies up and running. The Cannabis Control Board and the Office of Cannabis Management, they expect to at least have a basic staff this month. And we're hearing that they hope and intend to have draft regulations regarding the licensing and operation of businesses published and out by late summer or early fall. Now that has to go through the regulatory process here in the state of New York. There's what's referred to as the SAPA, the State Administrative Procedure Act, which governs how state agencies make regulations, and those we've got to get to that point. So that's going to take some time. All that's going to take some time. But people are moving quickly. The state wants to move. I mentioned, Massachusetts, it's already legal there. New Jersey actually legalized adult use cannabis back in February. They actually had a constitutional amendment several years ago. They just got the regulatory scheme approved by their legislature just this year as well. So people are moving forward. There's a lot of economic pressure to get this done. And so I think things are going to move pretty briskly as far as getting these cultivators in place, processors, distributors, and local retail establishments up and running. I think that's going to move pretty quickly. I keep referring to the MRTA. That was the act, again, the Marijuana Regulation and Taxation Act. It created a whole new law, Chapter 7-A of the New York State laws, known as the Cannabis law. It also amends many other laws. It amends the public health law, it amends the tax law, it amends the penal law, and we'll talk about a lot of that. We're not going to get in, we don't have time to cover everything in depth or detail today. We could have a whole day conference. We probably should be having conferences, multi-day conferences just on this topic. Another thing, and I already alluded to this, that it does establish two state agencies, the Cannabis Control Board and the Office of Cannabis Management. And one of the things I want to, and I'm relaying to my members time and again, is that in large part, the cannabis regulation is being modeled off of how the state regulates alcohol. It's not 100% match, right? I mean, it doesn't align perfectly. But in many instances, I think it's helpful for even local officials to think about cannabis regulation the same way the state regulates alcohol. And you'll see, in fact, in some of the provisions, they simply copied and pasted some of the provisions from the state's alcoholic beverage control law and put it into the cannabis law. I'm going to make sure this is still me. There are a lot of different types of entities out there that have to get licensed and approved by the CCB and the Office of Cannabis Management. Local governments really don't have any role in licensing or regulating the operation of these entities when it comes to the cannabis portion of that. And Sarah and I will talk a little bit about the difference between that and local regulation in a second. So there are different types of businesses. Cultivating, I keep mentioning that we're talking about the growers. Processing, that plant is taken and it's processed into either dried, or a lot of cannabis is put into different types of oils or extracted, put into edible form. Then you have distributors, you have delivery operations, and then we get into dispensing cannabis and on-site consumption establishments. And those are two hot topics for local governments, because local governments do really have the most control over those types of licensees within their jurisdictions. We're going to go into those in some detail, but I think it's important to note that, there are all these different aspects of the cannabis industry that are going to be regulated by the state, and you may see in one form or another within your community. Again, some of these you can regulate more than others. So real quick, legalization of use, and I'm going to talk about Penal Law Article 222 a little bit more later. Maybe Sarah's going to do that, I forget. Right now, and this is what's legal in the state of New York, anyone 21 years or older can legally use cannabis. They don't need a prescription from their doctor. They can possess up to, and I noted this earlier, they can't just have as much cannabis as they want. There are limits. So they can possess up to any one time 3 ounces of cannabis or 24 grams of concentrated cannabis. They can consume it. And also paraphernalia. So cannabis, marijuana paraphernalia is legalized, and local governments can't criminalize that, right? The state has preempted the field on this. I know a lot of communities over many years have had regulations regarding head shops and the sale of other kind of drug paraphernalia. When it comes to cannabis paraphernalia, that now is 100% legal in the state of New York, and local governments really don't have any authority to prohibit the sale of cannabis paraphernalia within their jurisdictions. And with that, I'm going to turn it over to my colleague and friend, Sarah.
Actually, Wade, I'm going to ask you a few questions.
Sure, absolutely.
I know that we're going to get into personal cultivation in a little bit, but with respect to the 3 ounce limitation, is that with respect to growing 3 ounces? And also, isn't there like 3 ounces is on your person, right?
On your
You're allowed
person,
to have
on
like
your
5
person.
pounds in your house or something.
Yeah, correct. There are different regulations from what you can possess in your home, and we will talk a little bit about that. Again, personal cultivation is a bit down the road, but just talking about on your person. So, for example, if somebody was walking down the street and they had 2 pounds of cannabis, that would be against the law. It's not allowed under the penal law provisions. And that's important to know. When we talk about legalization, we're not talking about the wild, wild west. We're talking about a regulated market. Again, just like there are regulations with the sale of alcohol, there's regulations with the sale and possession of cannabis as well. So again, different rules regarding personal cultivation, where you can do that, how much you can have at your home, both in as far as the number of plants and also the product that you have after. And we'll talk about that in a little bit more detail. That is not as urgent of an issue as the legal possession and use right now, which again, if somebody's walking down your city, village, town streets right now, and they've got a couple ounces of cannabis on them, that's legal. Other questions?
There was another question about some social justice issues, but we're going to get to that
later.
We'll
get to that some later. Yeah, absolutely. I'm going to turn this over to Sarah. So.
Okay. I'm also going to address the fact that I have my cat on screen. This is Ofa. She had a few seizures last night. We were at the vet early this morning, so she's allowed to do whatever she wants to do today. And she makes me happy. So, we talked about on-site dispensary licenses and retail dispensary licenses. So those are, Wade had mentioned thinking about it in terms of alcohol, right? So the area where municipalities have the most ability to regulate is with respect to essentially, think of like pot bars as on-site consumption sites, like just as you would go to a bar to have a glass of wine or, a cocktail, and then retail dispensary sites. So those are like your alcohol stores, your liquor stores, right? You don't actually open up your bottle of wine and drink it at the liquor store. You wait until you get home, right? Hopefully. Don't have it in the car. So the area that municipalities have the most ability to do any sort of regulation are with respect to the pot stores and the pot bars, the retail dispensaries, and the on-site consumption establishments. And cities, villages, and towns have the ability to adopt a local law opting out of allowing those 2 specific entities within your boundaries. Towns have a little asterisk next to them because if towns opt out and you have a village in the town, it only applies to the area town outside of village. Village would have to adopt its own local law opting out in order for that to apply. I'm trying to think if I want to say anything else about this, but no, Wade, you can move on to the next slide. So you have to adopt a local law. It is subject to a permissive referendum, and the local law has to be adopted on or before December 31st, 2021. So that's coming up really quickly. It's like a one or done shot, right? You have to adopt the local law on or before December 31st. If you adopt it on January 5th, 2022, it has no effect. So that's the big deadline that I want that we want you all to keep in mind is the December 31st adopting the local law. If you opt out of allowing retail sales or retail consumption, I'll call it on-site consumption within your jurisdiction, a new town board, a new village board, they can overturn that local law. And that would be it. So really the only opportunity to opt out of allowing retail sales within your geographical jurisdiction would be before December 31st. And again, that local law can be superseded by a future town board. And if it is superseded, it's not like you can go back and say, oh, you know what, we wanted to opt out. No, the only opportunity is to opt out before December 31st, 2021. Next slide, please. Good point. So some municipalities have adopted local laws prohibiting cannabis, marijuana, pot, whatever you want to call it. That doesn't they've already done that in anticipation, because as Wade had mentioned, this has been a discussion since 2013, right? So some municipalities have adopted, I would call them anticipatory laws, or, just in case laws. Those are not the same. Those are not going to have any effect. I feel as though those were more to make a statement about where the municipality was heading instead of having any sort of legal impact. So now that we actually have this regulatory and legal framework under which cannabis is allowed to operate, you would need to adopt a totally different opting out law. So I know a huge town in Long Island adopted a cannabis law in 2019, and they're like, do we need to adopt another local law if we want to opt out? Yes, you do. Next slide. As I mentioned, the local law is subject to a permissive referendum. It's subject to a permissive referendum under Municipal Home Rule Law Article or Section 24. And Wade's going to talk about a slightly different procedure for villages. But so if you're a town official, there's a whole separate process for permissive referendum under Town Law Article 7. That is not what applies here. There are a few differences, right? There's a whole separate procedure under Municipal Home Rule Law Section 24. And that's what you have to follow if you want to adopt a local law opting out of allowing retail dispensaries or on-site consumption sites. The local law is not going to be, so what would happen is the town board or the village board you're going to adopt, not the village board, the town board or the city legislative body would adopt a local law. Your residents would have 45 days to submit a petition with the appropriate number of signatures on it. Then if that works out well, if the petition is valid, then you would have to hold a referendum on it. It would actually go to the vote, so people would vote on it. And then if it were approved by a majority of the voters, then your opt-out local law would be in effect. If it is not approved, if you don't get a majority of the voters agreeing to opting out, then that's it. You do not pass go. You're not opting in, but your opt-out isn't valid. So I guess by default, you're in the biz, maybe. I also want to point out that opting out doesn't necessarily mean not opting out. If you don't opt out, it doesn't necessarily mean that there are going to be these retail sales that take place within your jurisdiction, because the Cannabis Control Board, which is the licensing entity for the state, they're the ones that are going to issue the licenses, and applicants are going to ask to open up in certain areas. I don't anticipate, just based on the way that other states have been modeled, I don't anticipate a pot store in every town, or a pot bar, again, on site. The law has all of these like legalese things, right? And I'm just like, no, it's a pot bar. Oh, but an on-site consumption establishment, the pot bar. Okay, guys, I'm just going to use colloquialisms. So not every municipality is going to have one of these in their jurisdiction, right? The applicant is going to say, hey, I would like to have a pot bar in the town of West Seneca. So just because you don't opt out doesn't necessarily mean that you are going to have these establishments. However, I do want to make clear too, though, that opting out is only with respect to allowing these establishments. You are not able to opt out of legalizing cannabis within your municipality. That is statewide. Okay. So it's only with respect to these two licenses. And I realize that I'm like jumping all over the place, but it's been a long night. Okay. A long night with the cat seizures. So Wade had mentioned a bunch of different licenses. I think that there are actually 10 different licenses under Article 4 of cannabis law. So it's really like a soup to nuts process. And it's really only at the end, the retail sales, when you get involved with the casual consumer for recreational pot, basically, that's where you have the opportunity to opt out. So anyway, going back to the procedure that's allowed under Municipal Home Rule Law, Section 24, as I mentioned, so the town board, the village board would, not the village board, the town board, the city legislative body, you would adopt your local law, and then within 45 days of adoption, a petition would have to be filed in the clerk's office. The petition would have to be signed by 10% of the registered voters who voted in the last gubernatorial election. That is actually one minor difference between Town Law Article 7 and Municipal Home Rule Law. Under Town Law Article 7, you're only required to have 5% of voters sign a petition. Under Municipal Home Rule Law, that threshold is a little bit higher. It's up to 10%. Some people might be like, okay, how do I know if somebody is a qualified voter? Practical recommendation is, right, talk to your county board of elections and get the list of people who were registered to vote in the last gubernatorial election. There might be a few people that you need to go and, do some more investigatory work on, but just as a practical matter, I think that is a decent, I don't want to call it a shortcut, but I think that is a practical way of determining if somebody actually is considered a qualified voter. Next slide. Oh, yep. Okay. So I already went over this. Signers of the petition must also be qualified voters who were also registered during the previous general election. And again, work with your county board of election to get that list on who was registered the last time. The proposition, so assuming that a valid petition is in fact submitted to the clerk's office, then the proposition is going to go to the voters at the next state or local government election, so long as there has to be 60 days in between the petition being filed and the proposition going to the voters, because the policy behind the law is you want to give voters a sufficient amount of time to consider how they're going to vote, to think, to really evaluate the process before they cast their decision. Alternatively, the petition can also request that a special election be held. So if the petition says that a special election has to be held, then you have to hold a special election. You can't wait until the next general election. Another question that I get asked a ton, and this is different for villages, right? I talked a lot about there needing to be a petition that's filed. So one question, probably one of the most frequently asked questions that I get is, are town boards allowed to submit their local law opting out to a referendum by their own initiative? So do you have to wait for a petition to be filed, or can the town board just say, hey, you know what, we want to put this to the voters? Unfortunately, under Municipal Home Rule Law, Section 24, the ability for the town board to, of their own initiative, submit something to a referendum is not available. That is another significant difference between Municipal Home Rule Law, Section 24 and Article 7 of Town Law. I know that there is a piece of legislation currently being evaluated that would give towns the ability to, of their own initiative, put something to a referendum under Municipal Home Rule Law 24, but I can't tell you if that's going to pass the legislature or if that's even going to be signed. If that is, you sure as heck can bet that AOT is going to be like, hey guys, you can do this of your own initiative. But currently, under the construct that exists, if you are a town or a city, you have to wait for a petition to be filed, a valid petition to be filed in order to put it to a referendum. Also, just as a practical piece of advice, if you're not sure where your community lies on this particular issue, if they want you to opt out or not, we've been recommending to our members, hold some community roundtables, hold some public hearings. You're not allowed to hold, you're not allowed to officially survey your members, right? I think, oh my gosh, I can't remember the phrase right now. You can't do a referendum just to gauge the temperature of how people feel, but have some public hearings, get some public feedback, ask for public feedback. If you're not sure how you want to go on this, there's nothing that would preclude you from doing that. And that way you I think you get a better sense of if somebody is going to actually file a petition. And then, will you have to go through the expense of holding a referenda, et cetera. Yep. I'm going to turn this over to Wade because there are special rules.
Yeah, and
for
I'm just
villages.
gonna, to hop on Sarah right there, just to point out that the local law has to be adopted on or before December 31st of this year. The referendum does not have to be conducted.
Good call.
In many instances, it's going to be impossible pursuant to state law for that to happen by the end of this year. Okay, I know we're getting questions from people. Well, do we have to have the referendum adopted to this? No, because it may not be able to get done pursuant to Section 24 of the Municipal Home Rule Law or even the village law. I'm going to breeze through this very quickly for a variety of reasons. In ICOM, we have a whole publication on how to conduct referendum. It's enacting local legislation and conducting referenda. So if you're a village, you can access it from our website. We're also going to be doing just a webinar on referenda in a couple of weeks. So keep an eye out for that for city and villages that are on the line today. But the process and procedure is different for villages. And the reason being is because the statute, the cannabis law that provides for the opt-out language, refers to Municipal Home Rule Law Section 24 and says that the referenda has to be conducted pursuant to Section 24 of the Municipal Home Rule Law. Section 24 of the Municipal Home Rule Law expressly refers back to Article 9 for villages and saying, hey, villages, you conduct your referenda pursuant to Article 9 of the village law. It is a different procedure. It's a different time frame. It's a different signature requirement. So I'm not going to go into detail here. I don't know how many villages we have online today to note this. One thing I will note that, and Sarah mentioned this, the legislation that's pending regarding towns. We've talked to legislators as well about making this applicable for cities. Village boards of trustees actually can adopt a resolution pursuant to Article 9, pushing their legislative acts to a vote of the public if it's subject to a permissive referendum. I say pushing, that's the layman's term that we use here. They can adopt a resolution saying, hey, this act that's subject to a permissive referendum is going to be put to a vote of the residents. It's in the statute. You'll notice here, again, the timing's different. The petition for villages has to be filed within 30 days of adopting the local law. The petition has to be signed not by 10%, but by 20% of village electors. And again, it's village electors at the previous village election, not at the last gubernatorial election. It is a different standard. So it's important, if you're a village, refer to Article 9 of the village law in that respect. I've already mentioned about pushing it to. One of the things I will note here on the timing issue, and this applies to towns and cities and villages as well, particularly if they want to get this on the November ballot, okay? So in years past, the election cycle for November elections was a little bit more condensed or compressed, right? Our primaries didn't take place until September. That's no longer the case. Our primaries are now in June, and the ballots have to be prepared by statute. I think is it August 2nd or August 5th this year? I forget. It's on the New York State Board of Elections website. And the reason being is because a couple of years ago, the election law, the New York State election law, was amended to put in place this new schedule, this new calendar for our November elections, so that ballots could be prepared in advance so they could be sent overseas to our military voters overseas and got back in time for the November election. The challenge with that is that if you look at the timing that Sarah discussed, like the 60 days, you can actually have a city or town adopt a local law opting out, and it may be more than 60 days from the November election, November, the first Tuesday after the first Monday, I forget which it is this year, but still it's too close to the election for it to get on the ballot for this November. So therein lies a challenge for that. For villages, as I previously noted, as on this screen it's noted, the election for a permissive referendum has to be not more than 60 and not less than 10 days from the date a petition filed, unless it's filed in the 2 months preceding the month in which you normally hold your election. Now, the reason I raise this, and again, I don't know how, I'm not going to belabor this. If you're a village and particularly if you're a November village, and your elections are normally in November, this is really problematic. The election law and Article 9 of the village law don't match up. You're going to have a problem or challenge complying with Article 9. Give us a call at our office. I'll just leave it there. Otherwise, if you're a March or a June village, you're going to have a special election. It's going to be held not more than, again, 60 and not less than 10 days after the date that the petition is filed or on the date that the resolution is filed. With that. So here's the example of the kind of dates. I will also note this. I'm sure people are going to ask, hey, can they get copies of this PowerPoint slide? And we will forward this on to Katie afterwards and she can send it out to everybody. It's also available, I should note this, free for everybody on our website, along with a summary. I have it nicom.org. You can just go there and download my previous version of this along with a sample local law opting out. I know Sarah has a sample law opting out. And we have a summary of the law there. So this is just an example. You would have a special election if you're a March election, if the petition is filed after March 1st, but before January 1st, June election, yada, yada, yada. I'm not going to belabor that point. Okay. And this is an example of when they would be on the general election ballot. Notice, however, again, by statute, for the November villages, it doesn't really work. Given the current election law. So give us a call here at the Conference of Mayors. If you're a village and you conduct your elections normally in November and you have a question about opting out, give us a call. And with that, I'm going to turn this back over to Sarah to talk about preemption and local regulation of
Sounds good. As soon as I hit send to this thing, send. Yeah, there we go. Okay. So as we had talked about before, the Cannabis Control Board is the licensing entity. That's the state control board. They're the ones who are going to review applications, who are going to promulgate regulations. And so counties, cities, towns, villages are preempted from adopting any law, regulation, ordinance, regulation, or prohibition pertaining to the operation or licensure of registered organizations. And registered organizations is just the law's way of referring to medical cannabis dispensaries. Also, if you're a recreational pot dispensary, you can also distribute medical pot. Adult use cannabis licenses or cannabinoid hemp licenses. Cannabinoid hemp licenses are basically like CBD. I always think of, so I'm from Buffalo and my parents live down the street from like the world's only still in operation Family Video, because people still go and they rent DVDs, et cetera. And on this Family Video like board outside, they say, we sell CBD here. And I always thought that was weird, that if you're going to go and rent a video, then you're also going to buy some CBD oil at the same time. I just thought that it was a curious combination. But what MRTA does is that it establishes a whole new regulatory structure for CBD oil, CBD, that kind of thing. So there are licenses involved with that if you want to sell that too. So so the state pretty much preempts municipalities from adopting any sort of regulation regarding the operation or licensing of any sort of medical pot, any sort of licensing for adult use, because again, that's the purview of the Cannabis Control Board or CBD. Again, you can adopt the local law opting out of allowing those physical places within your jurisdiction, but you can't adopt a local law on the operation saying that, it needs, like, the products need to meet a certain standard, et cetera. Next slide, Wade. You can, with respect to on-site consumption, the pot bars and the pot stores, you are allowed to adopt time, place, and manner restrictions, provided that these regulations do not make it unreasonably impractical to run. So you can't use your local zoning. You can't say, for example, that adult use dispensaries can only operate between the hours of 2 a.m. and 3 a.m. Okay, like that is not going to fly. Okay, that is going to be unreasonably impractical for those entities to operate. However, you are allowed to adopt local laws saying that they have to operate within a wider berth of time frame, maybe not before noon on Sunday, something like that. So there are certain time, place, manner restrictions. I know in Massachusetts, it's popular to only allow dispensaries in industrial zones. You do have the authority to say that you're not going to allow certain establishments in certain zones. You can absolutely do that. One question that I get a lot is the municipality allowed to limit the amount of licenses that are granted or limit the amount of establishments that are within your jurisdiction? My answer to that is no, I don't think that you are, because the CCB does have the exclusive authority to grant licenses. I know that the law specifically says that the board shall take into consideration the number of licenses already granted within a municipality. So, it doesn't explicitly say that, but reading everything all together, I would say that no, a municipality, you have the authority to limit time, place, and manner. You don't have the authority to limit the amount of licenses that are granted within an area. Time, place, manner restrictions also, if you have sign regulations in your town, those are a good example of time, place, manner, right? You have to think about I think sign local laws are a good model for time, place, manner restrictions in most instances. Okay, next slide. Again, just the soup to nuts construct of what's regulating. You can do the time, place, manner restrictions, and you can do the local opt-out only on the retail dispensing cannabis or the on-site consumption establishments. Going back to time, place, manner restrictions, all adult use licensees have to comply with local zoning regulations. That's not made explicit in MRTA. That's one of the things that I know that both NICOM and AOT would like to see. However, based on the time, place, manner restrictions, the fact that you are allowed to impose time, place, manner restrictions, and also there's another provision in there that says that an applicant has to submit that that their establishment would comply with all local permitting, local rules like that. So you are allowed to impose things like special use permits, site plan approval, architectural approval, so long as it is not inconsistent with what is permitted under cannabis law. So for example, there's a prohibition against allowing retail establishments within, I think it's 500 feet of a school and 200 feet within a place of worship. So that's what the state law says. You couldn't adopt a time, place, manner restriction that would actually allow those entities to operate closer than that. Okay, so that's what I mean. You've got your layover of state law, and then you've got room to tighten that up, not exceed what's allowed under state law, but you've got room to tighten up and impose these typical zoning regulations. One thing that I would caution with zoning regulations, if you do want to regulate time, place, manner through zoning, is that zoning is concerned with how the land is used, not who uses the land. And that's a really important distinction, because if you are going to use your zoning authority, you cannot single out cannabis establishments, okay? Because then you're getting into, I care about who uses the land, not how it's used. So if you wanted to do a time, place, manner restriction via your local zoning, it would be, no retail establishment can operate within, X, Y, and Z zone. You could not specifically single out and say cannabis dispensaries are not allowed within retail zones. That would be a regulation that's concerned with who uses land, not how the land is used. If you did want to use your authority to place time, place, manner restrictions via cannabis law, that's a little bit of a different story than what's allowed under your zoning law. So I feel like I'm getting into the weeds. There's so much opportunity for punning too with this cannabis law. I'm getting into the weeds here, but there is a distinction between allowing time, place, manner restrictions under the cannabis law and then using your zoning authority. So time, place, manner restrictions under cannabis law would allow you to actually impose time, place, manner restrictions on cannabis, on those retail establishments, and on those on-site consumption places specifically, but if you're using your zoning law, you need to be careful that you do not single out a cannabis establishment, because again, this is like one of the most important things with zoning, right? You're concerned with how the land is used. So just keep in mind the source of authority when you are considering adopting any sort of regulation or land use law on this. What about seeker? It's an unlisted action. You could have a negative declaration. I mean, it's still, a local regulation is considered an act under seeker. It's not a type 1 action listed under there. So yeah, regular procedure for seeker, but it is something, if you are going to have a local regulation, then that is subject to seeker. There's also something in cannabis law that allows notification to municipalities. So when a pot bar or a pot store is applying to the CCB for a license, they actually have to submit a notice to the municipality where they want to operate. And they have to list like what type of license that they're applying for, name, place, all sorts of stuff like that. And you have the opportunity to submit comments on that application. So again, you have the opportunity to opt out of retail establishments and on-site consumption places, but so let's say that you decide not to opt out and you decide to allow these establishments within your jurisdiction. So when one of those goes to apply to the CCB, you still have an opportunity to weigh in on the process. So let's say that an entity is going to submit an application for an on-site consumption site, and you have heard concerns from neighboring municipalities that they're not abiding by the law, et cetera, et cetera. You can submit your comments expressing your concern. Or maybe you've heard that someplace is particularly, you could submit a comment saying that you're in favor of this particular applicant. The board actually has to submit in writing a response or list of how they evaluated the municipality's comments in their decision to grant or deny an application. So if you decide not to opt out, you still have an opportunity to weigh in, because on adult use, retail dispensaries and on-site consumption licenses, because of this notification process, and the board can, if you want, submit comments, yay or nay, or just providing your general thoughts on the particular applicant and the application that's before the board. Next slide. Yep. Also, so a lot of different entities have the right to inspect. The Cannabis Control Board has the right to inspect. The Office of Cannabis Management has the right to inspect, but there's also the right to inspect entities or establishments at the local level too. And local law enforcement can inspect licensed premises in a manner so not to interrupt the ordinary business or compromise the safety or security of the operation. So, you can't go targeting an establishment for inspection with really the purpose to undermine their ability to conduct sales. You can't do that. But you are allowed to. I would also just as a general proposition, I would be mindful of making sure not to target any particular entity, whether it be cannabis or otherwise, right? You want to sort of enforce things in an equitable manner. So, just so local law enforcement, if you have a constable, if you have a peace officer, you are allowed to go and inspect premises of cannabis bars and cannabis stores.
And so I'm gonna take over here and talk about the revenue issues real quick. I just want to chime on. I mean, Sarah hit the nail on the head. Because we're getting a lot of questions too about these issues, right? I mean, all these licensees are still subject to local zoning regulations. We clarified this. I'll note that the time, place, and manner term that is actually in Cannabis Law Section 131 that's odd language. It's odd legal language because it's akin more to First Amendment jurisprudence than it is to land use regulations. So,
which is why I mentioned the signs. Yeah, it's weird. Yeah,
yeah,
I totally agree with that. It's so weird.
all the attorneys, I'm like, well, it's not what we would have recommended. I mean, it's just people are struggling with it. I will tell you, a lot of land use practitioners. Having said that, on top of this, and we get for all the other, like there's all these other licensees besides on-site consumption and retail establishments that are still going to have to comply with zoning. My recommendation is, and this is to think long and hard about this, right? Because again, the intent of the state is to treat cannabis in many respects, not exactly, in many respects like alcohol. If you were going to allow a liquor store in an area, why wouldn't a cannabis retail dispensary also be allowed in that area, right? If you were going to allow a bar in an area, why wouldn't an on-site consumption establishment also be allowed in those areas? And Sarah pointed out the distance restrictions, right? So these licensed retail establishments, retail dispensaries, and on-site consumption establishments have to be 500 feet from schools and 200 feet from places of worship. That's the same standard for alcohol and liquor license ease. Okay, so you can see how the law is similar between the two industries. The other thing I would point out too is, like, if you have a cultivator, and we've had a couple of people ask questions in the chat box about farmers and what have you, is it possible that somebody could be cultivating cannabis outdoors? It is possible. I think it's highly unlikely in the state of New York, and for two reasons. One, it's called winter, people. We have winter here, and it's not like California or Florida with more temperate climates where you can grow things outdoors, more easily year round. Another reason why is cannabis growing is a science. It is a science beyond belief. The amount of light, the type of light, the amount of water, the nutrients given to the plants, it is a science. They're growing so many different varieties of plants, and they want that controlled in indoor facilities. Does it have to be under the law? No, but I would be surprised if we really had any outdoor growing of cannabis in the state of New York. I don't think that from a business perspective, we're going to see that much in the state of New York. I do think, hemp, we're growing hemp right now. Hemp has been legalized in the state of New York for a while now and been growing. I think we're going to see probably more of that because of the MRTA. It does address some reforms to hemp sales. So we could have farmers in that instance deal with that. Going back, one final word to the land use regulations. So if you have an indoor grow facility, you would treat it like any other type of industrial or commercial establishment. You really do, to hammer this home, treating these types of entities or businesses differently than other businesses is going to be a huge red flag and a problem for many communities. So somebody asked about a moratorium, and I would advise against that. I think you need to get your zoning in order now. Like, hey, commercial retail, is it working for us now, as opposed to potentially putting in a moratorium down the road. The other thing I will note too is the state, and if you've been to any of the presentations by any of the state officials, Alex Burnaby or Norman Birbaum, who are the two officials in the governor's office who are really transitioning over to OCM and CCB, and are going to be spearheading the implementation of this in the state of New York. We've learned a lot of things from other states. They want to control the market, and by that means it's not going to be the wild, wild west. They're not just going to issue X number of licensees. If we look at Massachusetts, so for example, Massachusetts, I just talked to an official a couple of weeks ago. They only have a couple hundred licensees, and I think they're going to end up with about 400 retail licensees max. Don't quote me on that, but it's actually fixed in the Constitution as a percentage of, I think they've referenced alcohol stores or liquor stores. Anyhow, The state has a concern, not too many entities, because they don't want people to put money in and then go bankrupt or out of business. They don't want to flood the market again with too much product, because if you have too much product that's not getting sold and they can't make a business of it, that product goes somewhere and it goes to a black market, and they're looking to avoid that as well. They want these establishments to be geographically distributed throughout the state, but they don't want an over concentration. So again, as I mentioned before, we're likely to see all of these issues addressed in the regulations. These are issues to be determined in the regulations that get promulgated by the CCB and the OCM. So with that said, let's move over to the money, people, right? Hopefully this is going to be some good news for local governments and local taxpayers. The MRTA creates an entirely new article in the tax law. It imposes a tax on adult use cannabis products in a couple of different places. There's a sales tax both on distribution and retail sales. The tax on the distribution is going to go to the state government, and it's going to get a ton of money that it's going to do a bunch of different things with. There are different funds. There are like, I think, 3 different funds that are going to be formed to do different things, including social equity, drug abuse prevention, and law enforcement training. So they're going to set up these funds to achieve these different goals, and that's going to be financed again from the state sales tax that comes at the point of distribution. Okay. The retail sales, that's where it comes down to the local level. Okay. And specifically, tax law section 493, paragraph C, imposes a 4% local tax on retail sale of adult use cannabis. 1% of that, not 1% of the 4%, but of, so it's, you know what I'm saying. 1% goes to the county on the total sale, and then 3% on the total sale is going to go to the city, village, or town in which the sale occurs. There's no restrictions on these funds. These funds will go into your general funds. They'll go into the coffers for the local government. So they can be used for whatever purpose. They don't have to be used for law enforcement. They don't have to be used for drug education programs. It goes to the local government unrestricted. However, it only goes to local governments that host retail establishments. Retail dispensaries or on-site consumption establishments. Now, somebody asked about micro businesses, which they're very astute. They've read the statute, at least in part. And micro businesses are not subject to the opt-out provision, okay? And this is another reason why I put in the chat box, micro businesses are another huge area of to be determined. What exactly is going to constitute a micro business? How is it going to get licensed? What they can actually do? In many instances, the micro business model is designed and intended to deal with, or it's a social equity component, because to get into the business of adult use cannabis is expensive. And there are many, obviously, financial barriers to doing that. And if our goal, at least one of our goals in enacting the MRTA is to have some social and equity justice, if only rich people can get into it, all the people whose communities have been harmed by this, and maybe the local pot seller isn't going to have enough money to get into that business. They want to make that accessible, and that's where the micro business comes in. I don't have answers for you right now regarding micro businesses, what they're going to look like, how they're going to operate, again, to be determined. Having said that, going back to this, so if a local community opts out of retail establishments and on-site consumption establishments, it is going to get zero revenue, right? If you opt out, you will not receive any revenue from the local cannabis sales tax. Is it possible that at some point you could get some money from one of the funds created to kind of like finance a drug prevention program or a local equity program or local law enforcement training? Sure, but there's no guarantee there. You're gonna have to apply through the program and what have you. So again, if you want any piece of this pie, you can't opt out of the retail sales. Note also, and Sarah mentioned this too, even if you opt out, you've still got to have an establishment locate within your jurisdiction. there's one caveat with that I'll talk about in a second. So let's say I've got a village and they don't opt out, but there's no retail dispensary that locates within their community. Do they get any percentage of the retail sales? No, you don't get any money. You only get money if sales occur within your jurisdiction, or again, from one of these funds that you apply for at a later date. One quick word here, and I know that the Association of Towns didn't lobby for this, but for villages, if you have a retail establishment or an on-site consumption establishment within the village, and your town also permits retail sales, then the 3% is distributed between the town and the village as agreed upon by the governing bodies, or if they can't come to an agreement, then it's evenly divided. So stated differently, the village has a pot dispensary, and the town has not opted out. You're going to share that. If the town opts out, however, the town doesn't get any of that share, okay? So this is in the law. We don't know where this came from, why it treats villages this way and not towns. Like if the town has a retail establishment in the town boundaries outside of the village, they don't have to share with the village. It goes into the town's general fund and they don't have to share with the village. So that just is what it is. So personal cultivation, we mentioned that. There have been a couple of questions in the chat box. Very quickly, the law allows for people to grow their own cannabis in their own homes, right? Each individual can have up to 3 mature and 3 immature plants at any given time. Each household, no matter how many adults live there, can have up to 6 mature and 6 immature plants at the household at any given time. One of the things to note, that these plants have to be securely stored. They can't be accessible to minors or the public. You wouldn't be able to really keep them out in your yard and your backyard. They're going to have to be kept in a place where people can't access them. Cities, villages, towns, and counties may enact reasonable regulations regarding personal cultivation and home possession, subject to guidance from the CCB and the OCM. However, local governments, you can't prohibit personal cultivation or possession, okay? That's expressly preempted. A couple of things to note. Personal cultivation is not going to be allowed right away, okay? First of all, the state has to promulgate rules and regulations regarding personal cultivation. Those rules have to be adopted for medical cannabis users no later than September 30th of this year. So you can see here, the agencies aren't even up yet. It's June 1st. They have to have these regulations in place by September 30th for people who have a prescription for medical cannabis to be able to grow at their own homes. I'm assuming they will get up and running and issue an emergency regulation on or before September 30th. For adult use, so for individuals who don't have a prescription for medical cannabis, the Office of Cannabis Management has to issue regulations for adult use no later than 18 months after the first retail sale. So really, it's a long time before we're going to have personal cultivation in the state of New York for adult use, right? We're talking 2023, 2024 at that rate. So that it's not going to be anytime soon, just FYI on that front. This is back over to Sarah.
The dreaded I'm on mute. Okay, so MRTA does provide certain protections for cannabis users. This they want to be explicit with the legalization to saying what is not allowed or what protections are allowed for cannabis users. They don't want any sort of discriminatory behavior or enforcement taking place as a result of using marijuana recreationally or medically. So cannabis law section 127 prohibits prohibits discriminating against individuals for engaging in conduct that's permitted under the cannabis law. So this is just a general, I'm going to scale this back a little bit, right? Because I know that a lot of people are concerned about, oh, well, does this mean that you're able to like light up a joint in the workplace, things like that. But the general rule is that because pot is legalized, because cannabis is legalized, or anything else that's legalized under cannabis law, under MRTA, you cannot discriminate against an individual. And I'm going to drill that down a little bit if you want to move on to the next slide. So a good example would be with respect to housing. So landlords are not allowed to refuse to lease or cannot otherwise penalize an individual for conduct that's allowed under cannabis law, including consumption, unless it's subject to federal law. Because this is like a weird little rub here, because cannabis is still not permitted by federal law. Under the Obama administration, there was a shift in how they treated or how the federal government treated cannabis, and it sort of became like a rule of no enforcement, I guess, or a rule of lax enforcement. And that's why you saw a lot of state entities, start to legalize cannabis. So to be honest, I think it's still something that we're working out at the federal level, right? But so if you're a landlord and you receive federal funds, if you're subject to federal law in any sort of way as a result of grants, funds that you receive, assistance, then you are allowed to say no, we can't have cannabis. Also, don't forget that a lot of housing is private property, right? Private property is allowed to say what they want to happen on their private property. So if private property has a smoke-free policy, it's totally okay to say, no, we're not going to allow smoking on our property. That applies to housing, that applies to anywhere, really. Private property, you're allowed to prohibit cannabis consumption on your private property, just like you're allowed to say, hey, we're not going to drink in my house, whatever. Educational institutions, so schools, colleges, universities cannot refuse to enroll and cannot otherwise penalize individuals for conduct that's allowed under cannabis law, consuming, purchasing. A big thing to keep in mind is that, and I think that we've said this before, selling is not allowed. You have to be a licensed entity in order to sell cannabis. So if you got a college student who's also selling pot on the side to make some money, no, that's not an allowable thing under cannabis law. Again, the same caveats apply. So if the educational institution is subject to federal law, or if they have their own code of conduct prohibiting cannabis use based on a school's sincere religious beliefs. Some religious entities don't. Mormons, for example, don't even believe in taking caffeine. That's why you have, caffeine-free Diet Coke sales that spike in Salt Lake City, Utah. So if you have a sincere religious belief, if the educational institution has a sincere religious belief, saying that cannabis is not allowed, then the educational institution would be allowed to prohibit that. I think what you guys are probably more concerned with would be employer concerns. So labor law, section 201-G, bars employers from discriminating against individuals for cannabis use. So, when you're hiring somebody, you can't say, hey, do you smoke weed on the weekends, and then not hire them on that basis. If somebody posts something on their Facebook page, where they're smoking a joint over the weekend, you would not be able to impose any sort of penalties, any sort of discipline, assuming that they're doing it strictly in their personal, they're not doing it on town property, they're doing it strictly in their personal capacity, like they're clearly at their friend's house, they're not on the clock, nothing like that, and they're posting a picture on Facebook of them smoking a joint. You would not be able to then go in and discipline them or fire them, impose any sort of sanction in your capacity as an employer for that behavior, because that's allowed now. Consuming cannabis is allowed. However, and if you want to move on to the next slide, employers are not barred from discharging or disciplining an employee if doing so is mandated by state or federal law. So I know one of the big concerns would be CDL licenses, right? And CDL licenses require routine drug testing, right? That if somebody tests positive for cannabis during a CDL drug test, if they're impaired on the job, that would be a different scenario. So there's important things to keep in mind, right? Like you're not barred from, just like you're not barred from prohibiting your employees from drinking on the job, you're not barred from prohibiting your employees from smoking pot on the job. Also, you know, if an employee is impaired while on the job, right, you're not going to let a drunk driver get behind the wheel of a highway vehicle. You are not required to allow somebody who is clearly impaired from cannabis to get behind the wheel of a vehicle. It's not you know, a free for all, right? It's not a huge bacchanalia where we can do whatever we want anymore, right? I think it's useful if you think of it in comparable terms, as Wade said from the get-go, to alcohol, right? If there is an issue with performance, you know, if somebody is impaired on the job, then you are allowed to discipline somebody. However, you would not be allowed to discipline somebody just for enjoying pot on the weekends or, you know, taking a gummy when they get home from work. Therein lies the difference. Also, with respect to the sale of cannabis, and somebody asked before about in the chat box, if growers would be, if there's any liability associated with growing pot, you know, if there's like an accident later on or anything like that. I don't know how this is going to pan out because in New York State, you have dram shop laws, you know, where if a bartender sells alcohol to a visibly intoxicated person, you know, who is clearly impaired and they continue to sell them alcohol, there is the potential for liability against the entity that sells them that alcohol. So I don't know how cannabis sales are going to, if they're going to operate under the same like dram shop laws, but dram shop laws are a product that the court created. So I don't know if that's going to be explicit. I don't know if it's just going to be a product of case law. So that's something that's, as Wade would say, it's TBD, right? It's not CBD, it's TBD. We're going to find that out eventually. But generally, under Cannabis Law Section 85, you are not allowed to sell to anybody under the age of 21. A licensed entity is not allowed to sell to anybody under the age of 21. Again, you know, if you do home cultivation, you're not allowed to sell some of your pot to people because you have too much. You are allowed to gift a certain amount, but you are not allowed to sell it. You are not allowed to sell, an entity is not allowed to sell cannabis products to anybody who is visibly intoxicated. And it may not be sold if, you know, the person, if the entity suspects that it will be sold or given away in violation of state law. So, you know, same with alcohol, right? If you are over 21, if your friend is 22, okay, and the rest of your friends are 20 and you're all in the pot store like giggling, right? That's, the entity is allowed to say, no, I'm not going to sell it to you. Just as if you're in Wegmans or wherever, and, you know, any college student knows that the friend who's 21 goes in to buy the beer, all right? You don't go in with the friends who are 20. So there's that too. Is this still me? Okay, yes, it is still me actually. Okay, law enforcement impact. And this is kind of important, right? The odor, so it used to be like when a police officer would pull somebody over and they smelled weed in the car, that would be reasonable suspicion that something unlawful was going. And if you have reasonable suspicion, you're able to do a bunch of different searches, right? You can search wherever you think that cannabis might reasonably be. My criminal law professor said you can't look for a gun in the sugar bowl because a gun is never going to be held in the sugar bowl. So the same thing was true if you pulled a car over, if a police officer pulled a car over and they smelled weed, they were allowed to look for areas where there might reasonably be, or where there could be weed, which is a huge area in a vehicle. So now the law has been amended so that if a police officer smells weed when they have somebody pulled over, that does not create reasonable cause to search the entire vehicle. The exception is if the odor of burnt cannabis, if an officer observes the odor of burnt cannabis while they're investigating an impaired driving situation, then that creates reasonable cause to do further investigation. So, you know, I'm trying to think what it would be like akin to, like if somebody gets pulled over for suspected drunk driving and you smell alcohol in the car, all right, that creates reasonable suspicion. If the same thing applies here, right? If somebody gets pulled over for suspected impaired driving while under the influence, whether it be alcohol, and you think that somebody's driving under the influence of something and an officer smells weed in the car, that creates reasonable suspicion. However, if you are pulling somebody over for a broken tail light, a headlight that's out, and you get pulled over and an officer smells weed, that means nothing, okay? That does not create reasonable suspicion. The officer no longer has the right to search your car.
And I think I'll just add, because there was this kind of segues. There was a question earlier. There is, there's no analogy. We have breathalyzers to test if somebody has what their blood alcohol level is, right? You can't really do that with cannabis. We haven't come up with a test yet that will detect current impairment from cannabis just by a breathalyzer or even a blood test, right? And the reason being is because the metabolite for cannabinoids can stay in your bloodstream for weeks or months after an individual is no longer impaired or affected by cannabis. So there's going to be a fair amount of training for law enforcement on how to recognize this. They're called drug recognition experts, or DREs. The same thing's going to happen potentially for supervisors. Somebody asked that question as Sarah was covering the labor aspect of this, and how do you test somebody? I mean, we could conceivably test individuals for alcohol at work, but it's like, what does an impaired individual look like? What does an individual who is currently impaired by cannabis, by marijuana, look like? That's probably going to have to become part of training for supervisors in the workplace. And so again, some changes coming down in all parts of our society as a result of this. Another thing I will note is that I think we're going to have not only regulations adopted by OCM, but we're likely to have amendments to state statute to address certain issues as we go forward. So again, we are right at the beginning, and I think things are going to change. And this is one area where I think we may need some clarification. And this is where, and I'm going to end up very quickly. I know Katie's like, we're over. But this is an area where I'm getting a ton of questions here at the Conference of Mayors. Public consumption. What are we talking about? Smoking cannabis, pot, marijuana in public. The MRTA amended the Public Health Law Article 13-E, which is also known as the Clean Air Act. Now, I've been at the Conference of Mayors now here for 19 years, and when I first joined here back in 2002, we were still getting quite a few questions and inquiries about the Clean Air Act and what local governments can do regarding regulating smoking. Not so much anymore. It's been a long time. Most people, we reached a kind of a stasis of, where people were okay with smoking and not smoking, as the case may be. Article 13E was amended as part of the MRTA to add cannabis to tobacco in where it prohibits or restricts smoking or vaping. So now it applies again to tobacco and cannabis. And I'm not going to go through all of these places. It's very similar to what, again, you already know, where you can and cannot smoke tobacco. One of the things I will note, it addresses not only public places, it talks about school grounds or entrances to schools and libraries. It talks about school buses. Like, this is not going to be allowed anywhere or near anywhere where we might have kids, obviously. A question that we're getting a ton of, and Sarah, I'm assuming, is getting some of these as well, is can the local governments themselves enact their own more stringent regulations? The first thing to note is Article 13E actually expressly states that local governments are not preempted from adopting additional regulations regarding smoking. So if you want to go above and beyond your regulations, absolutely, you can adopt more stringent regulations regarding smoking and vaping. This is also to note a distinction. When I say regulation, I'm talking about public sidewalks, out businesses, things like that, regulations. Regarding your own municipal property, town hall, village hall, city hall, in your parks. You don't need a local law to do that. You adopt a resolution. That's a regulation, how people use your parks. If people are on there smoking on your parks, have them get off, tell the police that they shouldn't be there, that they should be, kicked off for trespassing when they do it that way. If you want to put a little bit more teeth into it and impose a fine or civil penalty or potential jail time, don't do that. But for smoking, you would need to do that via local law, right? But you could simply adopt a resolution saying, hey, no smoking or vaping of cannabis or tobacco in the town park or the city park. By resolution. That does not need to be done via local law. Okay. The one caveat I would say, and I stress this time and again, is I'd be very careful about adopting a regulation just for cannabis as opposed to tobacco. Okay. The reason being, and maybe I'm going to address both sides of this in a second. The reason being is that Article 13E treats them both the same. It does not differentiate between the two. And the state, again, has evidenced as part of the MRTA the fact that they want to make cannabis legal. It's legal to use and legal to possess, and we're going to have this whole regulatory scheme. And so, I just really caution local governments against singling out cannabis, marijuana in their regulations. Having said that, I'll note this. Cannabis smells more than cigarettes, right? I mean, you can smell it from a farther away. A lot more people don't like it. It's pungent, what have you. And so I know a lot of communities that are, well, we don't like tobacco smoke either, but it's not nearly as bad as cannabis. I think this is an area where I'm sure we're going to get communities that just regulate cannabis smoking, marijuana smoking, and not tobacco smoking. I wouldn't be surprised if we see those local laws get challenged. I don't know for certain how a court is going to come down. I would also say that I wouldn't be surprised if we do get an amendment to Article 13E that broadens or the prohibitions against cannabis smoking or authorizes local governments expressly to just regulate cannabis smoking it more stringently than they do tobacco smoking. That's just my hunch. I think a lot of senators and assembly members are going to hear complaints from the residents. Not everybody lives in New York City or, other places where, cannabis has been used commonly in public for a long time and people just accept it as part of living in that community. I think there are going to be some complaints that percolate up to the state level, and we might see some additional state regulation that addresses this issue. I just put that out there. Having said that, you can adopt more regulations regarding smoking, and I put that out there.
Wait, can I interrupt for just one
absolutely.
second? The one thing that I would add to on the flip side of, not just prohibiting cannabis, if you already have a smoking local law on the books that prohibits smoking in parks, wherever, I've seen this a lot of times. They specifically state that it prohibits tobacco usage. So if you are considering adopting a local law or local resolution prohibiting this, you might want to take a look and see what you have on the books and make sure that it's not just limited to tobacco. If you in fact want to prohibit cannabis.
That's great advice. That is tremendous advice. Review your local laws. Review your local laws periodically. I'm sure Sarah says that in many instances about other things too. As I mentioned this, right, it's at the very outset, even though it's cannabis and marijuana possession is legal to possess and use right now, there are limits. I'm not going to go through all of those. I highlight those in a summary document again, which I'll share with Katie, and you can find on the NICOM website. Generally, people who violate those, the lower violations are subject to civil penalties, but there are still criminal penalties, particularly like if somebody's carrying pounds and pounds of marijuana, obviously to sell, that carries some pretty hefty criminal fines still. We're near the end. I do want to talk, and somebody asked about what equity and justice programs. First of all, expungement of criminal records. That's something that is currently being worked on. the state court system, the Office of Court Administration, is working with the Division of Criminal Justice Services on how they're going to do that, because we've never really done that before. We've sealed records. There's a provision under state statute about how to seal records, but expunging criminal records isn't something that's been done really before, and clearly not in mass. And this could affect local governments, particularly what does it mean for local law enforcement? What are you going to have to do with your records? To be determined. We don't know yet, but you'll need to look at that. Some of the social equity programs, in addition to funds that are set up to help facilitate and people getting into the business of remedying the harm that was done by the war on drugs, they do have a goal. This is a goal, how this is going to work out, of awarding 50% of the licenses to social and economic equity applicants. And those include, as I mentioned in the chat, MWBEs. They include people who have been negatively impacted by the war on drugs. They include veterans and also farmers in that group. So it's a little bit of a broad category. Somebody asked about, well, what does MWBE? There's actually state definition, a state statute that applies to state, but not local governments. And I'm assuming that's what they're going to go off of. But I think we need to wait and see what the rules and regulations say. My assumption is they're not going to reinvent the wheel, but we'll have to, again, wait and see. So with that, questions? I know, did we have a time frame, Katie? Was this only supposed to be an hour? I don't know. But that's
I think
the end of our
technically it was going to be an
presentation.
hour, but this has been
Okay.
really good, and people are staying on. They're starting to drop off now, so.
So somebody made the comment. I mean, I see some comments here. You don't become intoxicated or impaired by walking through a group of people drinking alcohol in public or smoking cigarettes, but you can become impaired walking through a cloud of marijuana. There has to be a lot of marijuana. You have to stick around for a while. I'll leave it there. I mean, there's a learning curve. We're going to go through a learning curve here in the state of New York. We've got a long road to hoe, so to speak, on how this all plays out and what it looks like.
Yeah, I think we'll see a lot of
2, 3.
amendments, a lot of amendments to the law, to other areas where I think that there's a lot of unanticipated holes that exist, so I do think that we'll see, even after the regulations come out, a lot of, chapter amendments be made to things, a lot of case law. You see how it plays out.
There is what I refer to in a lot of training, the Newtonian principles of public policy. Every action has a reaction, and it's so, this new law, what's the reaction going to be? Time will tell. So, any more questions?
I don't see anything more in chat. We have went over, so we probably should wrap it up. I want to thank you both very much for sharing all of your knowledge about this topic. I think you addressed a lot of what we're hearing from our local governments. This video is going to be on YouTube pretty much as soon as this is over. I will send an email with the slideshow. We've been doing a lot in the chat too, so I'm going to try to capture some of the question and answers that we've done in chat in a separate document and send those out to you all as well. So look for an email from me sometime tomorrow morning. And in the meantime, thank you again, Sarah and Wade. Really appreciate you taking the time out to do this, and hope everyone has a good rest of your day.
Be well, everybody.
Take care.
Bye-bye.